And if I don't do it, then we kind of run out of slots, and we just need to keep on doing more, right? And so, just like always, feel free to ask questions between the segments. I'll be answering questions, anything you guys have from TikTok, from YouTube, from Instagram. And the two success stories that I'm going to be focusing on, one is NA3, which means you help your baby get a green card when you enter the US. It's a fun story, wholesome story, but it's actually quite complicated in the sense that there's misinformation out there. Second is about motion to terminate, meaning a client is about to be deported. How do we close out the case? This is happening not just with people who are illegal, it's even happening for people who already left the US. So this is a new trend, and we definitely want to go into talk about it. These are not long success stories. I'll just give you the facts, tell you exactly what we did, what you should do, and then we'll end it. But before we get into the success stories, I want to focus on denaturalization. Denaturalization is not something that most people should be concerned or overly worried about. I've already done so many consultations this past year about with people who are completely they can't sleep over this. Let's just put the numbers in perspective, okay? I mean, before we talk about the process, I'm sure you already know it, but let's just talk about the numbers. Up to 1997, there were about like 300 cases done, like from like the founding of our country till then, right? And then during Trump's first term, there was about 100. And mind you, it was Obama's administration that really pushed for it to start it. And it was during the Obama administration when he released those memos and USCIS and Ayla caught wind of it, and they were talking about it, that I started really paying attention to it, because it's like this could completely change the game for immigration. And since then till now, I've been following and I've been looking into it. And during Trump's first administration, there was about 100 cases that was pushed for denaturalization. And just now we got news that they're pushing it another 300. But let's just talk about that 300 number, okay? 300 cases for people to be denaturalized. Do you know how many people naturalized every single year? It's around 800,000 to a million people naturalize every single year. And that number might not be fully accurate, because that might be only counting USCIS numbers, but what about all the consular births around the world, right? Because then you don't naturalize, it's just your parents pass on the citizenship to you and you get it overseas. And that's, of course, not counting the people who are born as a naturalized U.S. citizen, right? If you're just born in the U.S., you become a citizen. So we're just talking about naturalized citizens, 800,000 to a million. 1% of that is 10,000, let's just say, right? 8,000 to 10,000. Do you think of that 800,000 to a million, 1% of those applications might have a glaring error? 8,000 to 10,000. Okay, that means 8,000, 10,000 every single year might have glaring errors in it. And what about if you multiply for the past few years? If you add all those numbers together, 300 is an extremely, extremely small number where they want to go and denaturalize. I'm going to pause and I'm going to talk about something else. Of that 300, how many of those cases, how many of those people are already overseas? How many of those people are already in jail? How many of those people potentially are fleeing the country or in the midst of prosecution? That's what I want you to think about and put in perspective, right? Not everybody who is a naturalized US citizen are like the mom and pop ordinary people who came here, filed an application, maybe there was a typo on it, and they're concerned over it, and then they have their families, they're working, they're paying their taxes, they don't have any other criminal records. It was just a form error, and they're losing sleep over it, right? I can guarantee you typos happen all the time, not even on the applicant's side. On USCIS's side, there are plenty of errors that happen all the time. And we just did a case, I think, a couple weeks ago where we did a success story where USCIS and the consulate made an error and gave everybody green cards when they shouldn't have. And then now during naturalization, they have to reverse it, but still granted new green cards and just have to naturalize again, right? So the government makes errors, individual makes errors, people make mistakes. Just because of a mistake doesn't mean the government is going to denaturalize you, okay? That's very important, because from the government side, Do you think they only get 300 requests to denaturalize people? They probably get like over 300,000. And then from there, they say we may only have the bandwidth to do the 300 because to denaturalize, USCIS has to give it over to the DA and go through the Department of Justice and go through a trial. It's very formal, it's very expensive, and they're not going to do it to somebody who can just easily get the green card and citizenship again. Right. So again, for most people that I'm talking to, if you are already a citizen, chances are you have a spouse that's a citizen, you have parents who are citizens, you have children who are citizens, you might have gotten citizenship a long time ago. If your citizenship is canceled, you can quickly get a new green card very fast and get a citizenship again. And so, in the grand scheme of things, 800,000 to 1 million people getting new citizenships every single year, 800,000 to 1 million. They're just canceling 300. They're just not canceling. They're just starting the case proceeding for 300 people. But we're talking about maybe for the past like maybe 5 years, 8 years of all the problematic cases, the ones that are most problematic, they pick out and they want to start a trial. And doesn't mean that they'll even succeed, right? So we'll see and wait to see what that happens. But think of all the enemies of the state who have left the country and fleeing prosecution. Well, they have a citizenship, they have rights. Well, if you can denaturalize them, then they lose out all the other rights within the country. Is it fair? Is it not fair? It's a policy that makes sense, and it was started by the Obama administration and being pushed through. We are still yet to see exactly how it carries out. If we begin to see normal mom and pop individuals are just getting punished, and it's a racist machinery, then I'll definitely bring it to your attention. But as far as now, right, all the consultations I've done, we are telling people this is not something you should worry about. But I'll take questions.
Yeah, can I naturalize if I have apply for citizenship if I have a one-time retail theft of $57?
Most likely that will fall under the petty theft exception. So remember that term, petty theft exception. Search it up on ChatGPT. Put your specific information into it. It depends on your state statute, wherever state you are in right now. It depends on your sentencing, but from what it sounds like, it sounds pretty minor. It qualifies for the petty theft exception, and therefore it is not an inadmissibility. It is not a deportability. However, is it a stain on your character? Yes, especially if there's a conviction. So now, with the new memo on the good moral character for citizenship applications, right, that came out in August, I think 15th, 2025, you want to prove with other things that you have good moral character. And the things that they look for, your education, your job, your assets, your community ties, etc. Right? So look at everything else. Does it overcome and you can just do your best to make a good argument, right?
Is it possible for to obtain legal status for someone who has absentia removal and is married to a U.S. citizen?
Is it possible? You want to see if you can get that case reopened, and you want to be able to get the adjustment of status adjudicated within the courts. It's going to be quite impossible to do it with USCIS. It's going to be quite impossible to do it at the consulate because there is already a removal proceeding, which is why I'm talking about one of these next success stories. You really want to go and reopen that case and get them to adjust. Now, you might have to apply for a waiver. You might have to do cancellation and removal. You might have to do these other things, right? And if you're married to a U.S. citizen, what you could do, at least at the bare minimum, is you could file the I-130 to prove the marital relationship. And once that gets approved, the courts are more likely and willing to adjudicate a case and get it reopened. This administration is not really reopening cases. They're reopening cases that they want to reopen. Cases that have been closed that you petition to open, they're usually not. There's a huge backlog, a couple million cases backlog, and the number of immigration judges are shrinking. And so it might be a long wait. But if your question is a very theoretical one, yes. But these are the steps, right? At least do the I-130, at least get the case together, at least you make the request.
In your view, how is the final merits determination for the I-140 EB-1A done?
How is it done? Like as a USCIS officer, what do they look for and how do they adjudicate, or how do we as immigration attorneys prepare? Or I guess it could be the same thing, right? How do we try to win it? So when I go to these conferences and I want to hear other experts talk about it, when I hear USCIS officers talk about it and look at their training manual, and then we've been doing this for decades now, the idea is very simple. Just purely comparing you to other people in that industry. So in the EB1A context, pick your profession. It's easy to meet the plain language of those, 3 out of 10 requirements, right? How many publications you have, et cetera, et cetera. And the most common thing is when we think about a professor. Of course, a professor has publications. That's the nature of their job, right? Of course, they judge other people because they control that dean, right? They're part of that the school of thought. So of course they play roles in judges. Of course, they're members of their elite groups and editors of their different law magazines, etc. So it's easy to meet the plain language of the three. However, you take a step back. Well, if every professor meets the 3 out of 10, are you necessarily one of the best professors that deserves a green card? So the whole final merits, it allows for that kind of adjudication where, okay, you do meet the plain language of the law for immigration, but are you truly the cream of the crop, best of the best? And so how we do it, how other experts have done it, and I presume what USCIS does when they evaluate these type of cases, is they take a look at the case and do a comparison. Now, of course, they don't know every single industry, right? Professor is an obvious example, but what if you're a rainforest frog, expert? Well, how do you compare to other rainbow, rainforest frog experts, right? They don't know that. They never studied it. And so you want to show them, in my country, this is how many people graduate with a master's or a PhD degree focusing on this specialty. There's only so many. And out of these, they work for the government, they work for these people. I'm the only one who is leading this area of experts and study. I am the cream of the crop, right? Out of the millions of people who study, I rise to the top, right? You want to give them that context. So that's what I mean by final merits analysis. Hopefully that helps.
So husband is a permanent resident. Based on the current visa bulletin, can I file for adjustment of status? Or do I have to wait and file I-130 first? My entry was legal.
Okay, repeat the whole thing again.
Yeah, husband, permanent resident. Based on current visa bulletin, can I file for adjustment of status? Or do I have to wait and file I-130 first? I had a legal entry.
Got it.
A legal entry.
Got it. It's definitely very complicated because there's a lot of things that's missing there, right? It depends on which country you're from. It depends on if you're going to try to do a waiver, right? But let's just start the first part. Just because you have a legal entry, the issue is, do you have legal status now, right? Did you continue it? Some people came in as a tourist visa, they changed to student visa, and they stay on a student visa for 10, 15 years. Do you have legal status now? Then that's, the first basis. The second thing is, assuming everything is current, or assuming your priority date is already current, and assuming there is no priority date, right? Then you can file the I-130 and the 485 adjustment status concurrently together. That's important to know. If it's not current, then you can only file the I-130, and then when it does become current, then you can file the 485. But sometimes some people have to wait an extremely long time before it becomes current. So what you should do is check out the visa bulletin. It published every single month. Every country, it depends on where you're born. The country is different, and depends on your status. Now, if you're already out of status, you came in legally, but then you fell out of status, then you cannot file the adjustment of status. You can only file the I-130, and that's where the second analysis comes in, where if you're thinking about a waiver, because you could potentially file, and then I-130 gets approved, you cannot file for adjustment of status, but you can file for a waiver, and then waiver gets approved, and then you go to the consulate, and they get the green card and come back in. But then you might think, well, why do that when the husband who's a green card could just become a citizen in a few years? And if a citizen petition you, then you can get it much faster without spending the money on the waiver, and it becomes much more straightforward in the U.S. So there's A, B, and C kind of an analysis. Hopefully that helps. I'm just saying there's a couple pieces missing. You want to take that information, potentially plug it in ChatGPT. You hopefully give you a much more thorough analysis. But if it's all still very confusing and your situation is more delicate, then I think a consultation would really help you.
Is it better? Does it look best for a marriage visa if it has some tenure rather than it being a fresh marriage? We're about to get married. Is it best for us to wait to file, maybe for a different administration?
No, I almost rarely recommend people to wait and change administrations because there's so many things that you're not sure of and you're really trusting luck. And who's to say next administration is going to be better than this administration in a particular context? That's just, yeah. Now, as far as whether or not your marriage is real and how an officer adjudicates that, I think the best thing to think about is there's two things to think about. One is the officer sitting on the other side. They're just a human being just like you. They went to school. This is their job. They're adjudicating hundreds of these cases. They think a lot of them are fraudulent. What are they looking for? Your marriage time is just one aspect of it. There's so much more to it, right? And so time itself is not the most critical thing. The second thing is sometimes you don't have the luxury to wait. Some people who, the whole adjustment of status, green card application itself could already take a couple years. And if it's a new marriage, you only get the conditional green card, and then you have to do a removal, and that could be another two years before you apply, and then that could be another 3-4 years before it is finally approved and interviewed. So we're talking about your wait time, even if you start now, could be 6-8 years. So if you're waiting, now we're talking about 10 years, right? Sometimes some people don't have the luxury to wait. Or if you're already illegal now, every single day you don't file, you don't have a receipt to protect you, you might be put in detention, you might have a removal order, and that might stop everything in its track. So I do not recommend just chalking it up to chance to say next administration. I would say focus your energy on building your case. You could do that right here, right now, right? You can build up how to prove your marriage is real. That's not something you have to wait for. Build it up, get your case good, and you file. And have the confidence that you're going to win. And use time to your advantage, right? If the case is going to take 8 years, then start building it for 8 years, right? As opposed to wait 8 years and then file, and hopefully it could be a little bit faster, right?
Are biometrics paused? I've been waiting for 145 days to do biometrics for the first time.
That's an extremely long time. We usually see biometrics, within 3 months. So you're almost at the point of doubling it. Is it paused? There's definitely no pause. We've seen biometrics all rolling forward. In fact, they're mandating it to increase. I would definitely check with USCIS to see if they've issued it. You could call the 800 number. It's extremely problematic answering service. Just have a lot of patience, but eventually you'll get through. Talk to a tier 1 officer, talk to a tier 2 officer, check on your biometrics. If they haven't issued it, they're just delayed, but it's definitely not paused.
I have DACA, clean record, but a removal order. Is it safe to travel by plane?
Less and less so. I would not recommend it. TSA has all the personnel information of the people who are on flights. It's transferred to CBP. ICE has access to it. So even if you're traveling by plane domestically, if you have a removal order, ICE could show up on the other side and could pick you up. So I would be cautious.
Do you know if probation alone triggers mandatory detention?
I do not know that. Yeah. I haven't looked into it.
I have DACA from one of the 39 countries that are paused. I believe that's total USCIS pause. It expires January of next year. How early can I apply to avoid losing DACA?
You are from those countries that are paused, and you are also on DACA. What is the 39 country ban? Is it just a visa or any immigrant benefits?
Let me check. I think it's the same as the 19 country USCIS pause.
You know, I don't know this answer, but I would just apply as if the ban wasn't there. And a couple reasons for that. One, DACA is a deferred removal. It's not necessarily an immigrant benefit. Two, because DACA has already been paused. So if you already have DACA, you definitely don't want to wait for it to lapse, right? I'd rather take the gamble of filing and have them just not adjudicated than missing it and then losing out on DACA forever. So those are the two reasons why I would just file. You lose out the filing fee with USCIS, but at least you did your part.
A U.S. citizen filed I-130 in March 2025 for Indian spouse currently living in India. When can I expect the approval?
I think the processing time is about 1.5 to 2 years or more. But yeah, so it sounds like it's going.
Okay. Any updates on the 75 country visa pause?
Nope.
Are you aware of any approved exceptions, national interest exceptions?
I am not aware. Yeah.
Do you think the government may gradually add exceptions, such as the EB-2 NIW?
I don't think many people are working on it. Honestly, I don't think they're. I mean, with everything that's going on, there's so much emphasis on so many other things. I don't think this is a high priority for the government. I think it's all case by case basis. So I don't think they're going to come up with any memos saying these are some of the exceptions and whatnot. I think if you have an EB-2 NIW, you just apply for the exception. If you have an O1, just apply for exception. Just keep on applying for exceptions again and again, and maybe the consulate would approve.
How long do you have to file an appeal on a 42B case?
I don't know. We don't do removal defense that much.
Okay, I got granted by the judge on a cancellation of removal. Does the pause affect me getting a green card?
Most likely, because even though the judge granted it, it's still going to be USCIS Processing Center that issues the green card. And so if the ban affects you from your nationality, that could still be a pause. But at least you're safe.
Can someone prevent the 5-year ban when they go to the consulate appointment for the visa?
Can they prevent the 5-year ban? I'm assuming you mean if you have a 5-year bar to re-enter the United States because your visa was, terminated, and you are trying to reapply for a new visa, are you able to get it before the 5 year is up? And the answer is yes. You can apply for the D6 waiver, and you explain your situation. The consulate feels for you. They could put a request in to Washington, D.C. It takes about 6 months or to 9 months. It gets approved. They call you back in. They give you a new visa. So, yeah, it's totally possible. And we've done success stories on it. Relatively recently, we did one where it was a tourist visa and got the waiver. I mean, which is unheard of, right? Like most of the time, if you have a ban, it's really hard to get any sort of waiver, and you want to tie it to something that's strong. But having a tourist visa is pretty awesome.
Yeah, for extra context, they have an absentia removal and are now trying to get a visa.
Oh, okay. So yeah, you definitely need a waiver at the consulate.
For bona fides, I submitted wedding pictures, honeymoon pictures, proof of regular phone conversations. What are some other things I can submit?
Oh, so many. And be as creative as you can. But most importantly, think about things that fraudsters would not have, could not have, but you have. So everything you mentioned, somebody who's scheming to try to create a fake marriage can easily get joint bank statements, call records, right? Photos together. And their photos are probably better than yours. They hire professional photographers, they stage it, it's a profession that they're doing. So What do you have that other people just do not have? That's the stuff that you really want to think through, right? Um, Living together with each other's in-laws, well, that is uncomfortable for many, couples. But if you do that, kidney transplant to relatives, that's a big gesture, right? Think of your own K drama, your Indian drama, your Chinese drama, your Japanese drama. Think of your own unique story that nobody else would do. And that is something that is pretty apparent. Now, if you're young, you're in your 20s, naturally you have a lot of social media. And if you blast each other's, Facebook, Instagram, TikTok, and you have basically in front of the whole world announce each other your relationship, that is something fraudsters generally can't and are not willing to do, right? So these are the things to kind of think about.
What if it's a gay couple and the family is homophobic?
Okay, so do you guys do counseling? Do you guys go to counseling, as in you guys do counseling for others who are in your situation, or you guys are receiving counseling for this marital conflict? Now, that's very much a private situation, but at least you're seeking professional help. And so you have these kind of documents, right? Are you part of groups that are within that space? If you're young, the different clubs that you guys go to, if you guys are the clubbing type. If you're not the clubbing type, then what are some places that you guys go that mingle and also have the support network, right? It could just be friends, but it could also be book clubs, for example. Yeah, those are the type of things that you want to build and think about. When DOMA was first struck down, I forgot when, 2016, 2017, it was a big deal. USCIS took a lot of effort into trying to make sure that they don't discriminate. And so there was a lot of training. And we have a lot of USCIS officers that were in part of that period. And then they left USCIS and now they're attorneys, and we work together on a lot of these type of cases. And so just because it's a, same-sex case, it's not necessarily heightened anymore because they have so much training and background on it. So it's really just the same as any other relationship. So just want to prepare the package accordingly. How you interview matters a lot, right? What's on your phone matters a lot, right? If you scroll both of each other's phone, same apps, same conversations, those are really important.
Yeah, I remember we've had a success story on our YouTube about like a lesbian nun couple where they had to kind of keep their relationship secret from the public. Do you remember any like documents we provided there when they had to keep a secret relationship?
Yeah, that was a really hard case because the family didn't know about it.
Even their friends didn't know
about it. Their friends
right?
didn't know about it. They don't have a lot of documents because they're like nuns. So they don't have, it's not like they live very flashy lives. They don't use social media. They were an elderly couple. I think back then they were already in their like late 40s or so. They don't have any prior relationships. It was just really, there was nothing to go on. And the officer actually made them swear their oaths to each other to talk about their love. And they're Asians, and so they're not vocal in their affection. And so that was also a cultural, teaching moment for the officer to kind of explain. The case ultimately got approved, but we actually had to rely on different agencies to kind of help out and talk about their relationship and talk about their culture, right? So it's a hard case, but it's winnable. And again, don't focus on just the normal, ordinary things, right? Now, if you have it, it doesn't harm you to include it. But again, the context is, to the officer, out of 10 cases, 9 of them are fake.
Any updates? I know we just talked about this. Any updates on the 75 country ban? There was recent news about a court case that is currently pending.
Right. I don't think it's going to go through, but that's my opinion. And again, like I said, I think it's going to continue, and potentially even more countries might be added to the list.
Okay, I want to get into some success stories. Feel free to keep putting your questions in the chat. I'll take note of them. But yeah, what is our first success story for today?
I want to talk about NA3 first, right? NA3 is when a green card holder mother gets her baby a green card when they enter the United States. If you're searching this online, you will see conflicting information. You'll see, oh, do it at the consulate. You'll see, oh, just directly do it at the border. You'll see directly do it with customs at the airport or at the border. And I want to clarify the whole process and how we do it, right? Again, if the authority falls on the customs officer, and the law is a green card holder mother who leaves the United States and gives birth upon their first entry back within the 2 years, that baby can get a green card. And that policy makes sense, right? You know, some people travel and inadvertently get pregnant and give birth and they can't come back. You know, the baby should be a green card holder. Now, if the father or the parent, the father is a U.S. citizen, they potentially could directly transfer the citizenship abroad at the consulate, right? But if the father is also a green card holder or not a green card holder, just a foreign national, the green card mother should at least pass on the green card status, the lawful permanent status to the child. Now, over the past, I don't know, 7+ years now, where I've been going to the border, talking to the officer, I could tell you that officers really don't like doing NA3 cases. People at the customs at the airports don't like doing NA3 cases. And the reason for that is because it's a huge responsibility. You're filling out the form, a simple form, a very, 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 very simple form. My library card application here is more complicated than an NA3 application with a port of entry. It's a simple form, but it's a huge responsibility because you're giving a green card. And so they take it seriously. At the same time, customs, they're just overworked, right? Overworked, underpaid, they have too much responsibility. At one point, they're tracking, smugglers. At another point, they're doing like Disney IP theft, and suddenly they're investigating if somebody's intent is a student or not. And then suddenly a mother shows up with a baby and wants a green card. And they have to do that within a few minutes, right? Like, it's a lot of work. They don't like doing it. But it is their authority and it's their obligation and it is the law. And that's why we've seen in the past 5-6 years, so many people read it like, oh, I could just go to the border. I could buy a plane ticket, fly to the airport, and my baby gets a green card. And some do, right? Some do, and great. But we also see the tragic situation where they get turned away. And once you're turned away, the NA3 doesn't qualify anymore because it only applies the first time upon entry. And the second thing is a nightmare situation where the officer actually takes away the mother's green card, right? If you search on our YouTube channel, you'll see a story we did. I think it was 2 years ago. I remember, I was in Orlando where I got the call like Sunday night, and a mother was taken to custody and green card was confiscated. She was trying to do NA3 for her child, but the officer said the mother has been out for too long, so mother abandoned the green card. Therefore, the child doesn't qualify. That happens more often than you think, but it was one of the first times where the mother's green card was actually confiscated and going to be forced to be abandoned. So I flew back from the AILA conference. Next day, spent a whole week, and we tried to get it. We got the mother's green card back. She wasn't canceled, but the child, unfortunately, couldn't get the NA3 and had to fly back. And what happens then? Now the mother has to do the original and traditional filing with USCIS, file the I-130, go to the consulate. It could take years. It could never happen because the mother might not ever come back to the U.S. and she doesn't meet the physical presence test, so the child can get the green card. So basically, this one mistake at the border, or in this case at the airport, caused the child not to have a green card for potentially forever. And that's just the situation. Now, what do we do? What did we do in this case, right? So this was Amy's team, spent a good few months working on it. And it was actually the solution, I guess I should say, is relatively fast. So we applied it with the consulate first. And the consulate application wasn't that difficult. She prepared everything, coached the client how to answer, filed it, and within like a month and a half, she got the visa approved in her passport. I mean, I think we spent about a month preparing. We filed it about a month and a half, got the visa and the passport, and within a few days, 2 weeks actually, she flew with the child into the US, and we prepared an entire entry package to the customs officer. We always do it, rarely ever used, but we do it out of abundance of caution. The officer looks at our entry package, questions the client, looks at the visa, And we've never failed. We've never failed at NA3 when we do it this way. Why? Because to the officer, the form is already filled out. There's an attorney preparing the brief. It's very clear. The consulate approved it already. To them, if so many people are attesting for this application, they are not as responsible. It's easy. They can approve it. And within, I think, less than 10 minutes, entered. And the good thing about it is because it's so formal and straightforward, less mistake is likely to happen. Because we also do other cases where the client successfully did the NA3 at the airport or at the border, came in, but USCIS never mailed them the green card. And then they had to leave, and suddenly they're in limbo because they entered with a green card status, but they never got the green card approval because maybe the officer didn't send it into USCIS. Maybe there was a mistake on the form and a mistake on the number, and we have to do I-90 and we have to appeal. There's all sorts of problems that happen if there's a human error. And again, you're just showing up in front of an officer trying to get a green card, filling out a paper. Of course, errors happen, right? Now, if you stayed in the US, you could have a chance to correct it, but what if you had to leave? So for all of those reasons, the way we do the NA3 is we do it at the consulate. And a lot of people are scared to go to the consulate. They think it's a lot of extra work and a lot of extra time. It is not. I want to just let people know it is not that complicated. You just prepare it well. It is far simpler than the other alternative, doing the I-130, going through the National Visa Center, going to the consulate, and preparing everything else. That is way more complicated. This, in comparison, is maybe 20% compared to that, right? So you prepare well, you coach the client, they do it, they get the visa in their passport, and then you face the CBP officer, and then you present everything, right? So it's a two-step process, but it makes the second process, the most important process, just that much better. It's a little bit more work than just showing up at the border and say, hey, and with your mouth kind of explain, hey, this is my child, please give them a green card. But if you want to do it right, do a little bit more work, it almost guarantees a success. And that's what Amy did. And we just, I was on standby when the client was in New York, and they flew in, and, it was very smooth. And I didn't even have to talk to the officer. But I'm always there in case the officer does have any questions. So that is a success story. Props, Amy.
Is Djibouti on the list of 75 countries? And so it's not, but do you think it'll be added?
I don't know. I really don't know what's going to be added, but it is my theory that the officer is going to add. I think a good place to look is the non-immigrant visa bond. How many countries are on that list? And that's my theory, that those countries might be added onto the 75 country, if not more.
Any reason why employment authorization process / DACA is taking so long?
Is because it's on the chopping block, right? It is a low priority compared to so many other things that are high priority.
Okay, so feel free to keep adding. Is the N470, is that only for government workers?
Nope. Research organizations, international organizations. So, if you work for the US or contractor for the US or the subcontractor of a contractor for the US. That's what we did in this recent case that we did last week, right? It was contractor of the US government and their subcontractor and their subcontractor's personal hire. It was a long shot application, but it still got approved. And I think it was only a few months, like 2 months or something like that, less than 2 months. It was a very fast application approval. So we're very happy about it. But that's on the government side, right? But if you're working for a big, international organization, UN, Red Cross, totally works.
Okay, so feel free to keep adding questions. Is it okay to leave the US as soon as I-131 is filed and received, as long as I fly back in time for the biometrics? Or do you have to stay in the US until the biometrics is done?
We have seen plenty of clients. Once USCIS receives the I-131, you get a receipt or something confirming that they received it, then you leave. And then you fly back for the biometrics. You can extend the biometric 2 times, I think 2 weeks each, and then fly back and do it. You can always do your biometrics before, you can't do it after, right? So you definitely want to schedule and then do it.
Okay. Feel free to keep adding questions. Let's jump into success story number
Okay.
2, though.
All right. This is a new trend that we're seeing where people are getting notice of intent to appear the moment their cases get denied. And this is extremely important because it is going to lead to the next wave of problems that people are going to face. In this case, it was a mother who was visiting her daughter on a tourist visa. She filed the extension, she had a surgery, and the extension took so long that she just decided to leave. But the case was denied, and then she got the notice of intent to appear. Luckily, she left before she received the notice of intent to appear. And you might think, what? Why would she get a notice of intent to appear at an immigration court for a tourist visa saying that she has to leave when she's already left? This seems really dumb and a waste of taxpayer money. It gets worse. That is obviously what everyone thinks. And we obviously reached out and said, can you just close this trial, please? Right? Like the person already left. It turns out the trial attorney couldn't be reached because she was out of the office. The court couldn't be reached because they were in backlog. And so it's up to the trial attorney. So nobody could respond. We have to show up for trial. During the trial, at least we were able to be placed first and say and make this request. Please just close out this case. The client already left. The trial attorney wasn't willing to. The trial attorney said, I don't know if she left. And the court and the judge looked at us and we said, you literally represent customs. You have it in their data bank. There was a I-94 record of her leaving. You can check. We already provided a proof that she left, the plane tickets and everything. And the trial attorney said, well, I can't go based off of the proof that you provided. Well, you have access to the system. Why don't you just check it? You had all this time to check it. You have time to check it before you issued the notice of intent to appear. Why did you issue the notice of intent to appear before checking? Why didn't you check? The judge was actually quite fond of this argument and said, do you have access to the system? The trial attorney reluctantly said yes. Then the judge said, well, can you check then before we decided we should terminate this proceeding, right? Because the alternative is for the trial attorney to say, no, let's kick it to the next hearing and let's wait, 3 months, 6 months, and then come back to this trial. So 2 trials for a case to determine whether or not this old grandmother have already left the US or not. The judge asked, can you please check the system? They're like, all right, fine. But she couldn't log into the system. It was like glitchy. And so we were bumped down to the end of the line and we have to wait for everybody else's trial to go. And then finally, in the end, when it got back to this case, the trial attorney said, all right, I see that she has left. And then so the judge says, okay, so do you agree to terminate this case then? Right? Because the attorneys requested to terminate this case because the person already left. The trial attorney said, I will defer to the court. That is the situation at immigration court today, where trial attorneys cannot make common sense decisions because they're under so much pressure to oppose everything that is pro-immigration. Mother, right? Like that is the situation we're in today. And the trial attorney, the judge said, fine, we'll close out the case. We closed it. Now, had the mother left the US after she got the notice of intent to appear, this would be another argument entirely. The trial attorney could have said she's fleeing the country, so we're going to put it on her record that she is removed in absentia. And think about that. All right, let's assume that does happen, right? Not everybody can hire an attorney to do this sort of bogus trial, right? Where you go up and you purely state, I've already left. You're telling me to leave, I already left. Like, what's the point? But had they not done that, even this case would have been in removal in absentia. And if she does have an removal in absentia order, good luck trying to get any other visa to come back to the US, right? Again, this is a grandmother who came to the US to visit her daughter, had surgery, had to stay, pay out of pocket and everything, and then filed an extension, paid for the extension, but it was taking so long because the government is so slow, and then she flew home. Something so simple, but now suddenly she is in the same bucket as everybody else who got removed for being illegal in the United States, and she lose out on all future privileges of getting a visa. Think about that. She had to spend extra funds to pay for an attorney, to go to a hearing, and we try to save her money by saying we'll try to request that we don't even have this trial, so we don't even have to go. The court, the system just didn't allow for it. We had to go to the hearing. We went to the hearing. We tried to close it. They wouldn't be willing. They're not willing to close it. There was going to be a second trial for something so simple. But that's what we're seeing. For people who are coming in as tourist visas, filing extensions, for people who are overstaying their I-94s, for people who have their student visas, revoked, canceled for all sorts of traffic ticket reasons, and now they're getting an NTA. And that is not something you take lightly. I know in other situations in American civic life, right? Oh, you have some library books that are overdue and you forget to pay, you pay a penalty, right? Some things are not that severe. But a notice of intent to appear is something that needs to be dealt with. And unfortunately, the situation in the climate that we're in, there's so few immigration judges, the cases are so backlogged, and trial attorneys are required and ordered to oppose everything, even if it doesn't make sense, even if it's contrary to justice, grace, and peace. So hopefully everybody who gets a notice of intent to appear responds on time and is able to reopen if they got in absentia removed and be able to close out that case. But this is going to have a lasting effect on American civic life for the next 20, 30, 40 years, because everybody who gets this, a lot of people who got it, they don't even know they've been removed until they go back for another visa appointment years later. What? I've been deported from the US? That's a new reality, right? People have been deported and they don't even know they got deported. But we close out the case. The mother's happy, the daughter's happy, we're happy, and in the future, we'll see what happened to them. If they want to get another visa, at least they don't have that stain on their record. Those are the two success stories I want to share with you, and today's news was about the denaturalization. If you guys have any other questions, feel free to ask.
Yeah, how could I contact you?
You could go to our website and you can book a consultation. And depending on the language preference, depending on the time preference, you can book accordingly. There's a lot of different people who can help you. We try to create our website and scheduling so we can help the most number of people and as fast as possible. And for that reason, you can book with me. But if you really, really only want to talk to me, then just book an appointment and request, I only want to talk to Joseph, right? We'll make it happen. You might have to wait a little longer. But a lot of people who are in immigration situations, they have dire needs that needs to be, dealt with within a week, within 2 weeks. And, if every consultation just depended on me, we'll never be able to save everyone, right? And so our whole team is on standby being able to help as many people. And so if you have an issue, if you have a question, if you have a concern, again, my team is amazing. I trust them wholeheartedly. And, most of them have been here for an extremely long time. And if they don't know, they'll tell you they don't know, and they'll find other people who know. I don't even know everything, and then we'll get you the answer you need.
While pending asylum, my EB-2 was denied and referred to court. I have EB-3 approved. Can I adjust status in court?
You would first have to close out your asylum case. Your prior date has to be current. Then you can file the 45. And your standard of proof is significantly higher. Now you have to prove by clear and convincing evidence, which almost pretty much means your case has to be 99% flawless. Possible, just hard.
If I join the military, can I help my parents get their green card? And how long would that process be?
Yeah, look at parole in place, right? It is still alive and well. Every USCIS service center does that a little bit differently. Some people want a written statement, some people don't. Check with your local USCIS office on their exact requirements. I know it's hard to be able to do that, but look first at what the general requirements are for parole in place. again, if you're joining the military, they usually have, I think, JAG attorneys that are trained with immigration. And of course, if they can't do it, they usually reach out to AILA for pro bono help, and then a lot of the attorneys go and help. But you should be able to get the right resources to be able to help. But it is definitely alive and well, and you could potentially do it.
My 42B was put on reserve by IJ
Immigration judge.
in 2023.
Okay.
But QR is
Hmm.
aging out
Hmm.
soon this year.
Hmm.
Do I, father, lose benefit?
Say the whole thing again.
Yeah, 42B put on reserve by IJ
Uh huh.
2023.
Uh huh.
But QR
Qualifying relative.
is aging out this year.
Uh huh.
Does the father lose benefit?
Does I don't think so, but I might not be understanding the fact pattern correctly. Cancellation or removal is based on your good moral character in the country. And so it is not really dependent on any quote unquote qualifying relative. Any qualifying relative, quote unquote, is just is not you're not based your approval is not dependent on them. Your approval is dependent on your good moral character and how important you are to society. And aging out is a CSPA concept, and presumably they're born in the US and they are a citizen already, and so they don't need your cancellation or removal. But if they are a child and their status depends on you getting the green card and they're aging out, then you have to look into whether or not CSPA can protect them. And to my understanding, I don't think it does, because I don't think it freezes the age for cancellation or removal. They might be able to do their own 42B if they're unlawfully present in the US. But, CSPA, Child Status Protection Act, for people who are aging out is really reserved for I-130s, 45s, and EB-5.
I have an appointment at the NBC, but I got in trouble with a DUI. Will I be denied?
A single DUI is not a inadmissibility and a deportable offense, but it does call into question good moral character. And so you want to do everything else to kind of overcome that. So definitely do your best. And there's no guidance on the consulate good moral character compared to the US citizen, where there's a clear memo that just came out last year. So my recommendation to everyone is just take the US citizen good moral character and bring it over to the green card application portion and review everything and try to do your best to make the same arguments.
Okay, that is our time for today.
Well, thank you. And I'm glad this is the first time doing 2 success stories. It was short, but I think it was helpful. Thank you, guys.
Okay,
One more question?
last question.
One last question.
I have a wife in Vientiane, Laos. And what should I do about when she will be able to come to the US?
It's just a long way, but the I-130, the NVC, and then the consulate. Just make the way and petition and work through the system. If you can't wait, or if it's beyond processing, you can always get your senator and congressman to kind of push USCIS.
Okay, thank you, everyone.
Okay, bye-bye.
And we will